Supreme Court release orders about Illinois' gun ban and whether they're going to take the case on an interlocutory appeal. What does all that mean? Well, hopefully we can boil it down for you. I'm Greg Bishop with a special edition of Bishop on Air. And again, I want to remind people, if you've come to this channel to get daily updates of what's going on in Illinois, go to America's Talking Network on YouTube, like, subscribe, and hit notifications there. At a date certain, that daily live program every morning is going to be only on America's Talking Network on YouTube. So be sure to like, subscribe, and hit that notification bell to get Illinois in focus daily. But on occasion, I'm going to do a Bishop on Air segment for you guys, specifically on the Second Amendment, because really that's where a lot of you have come to this channel for. So I want to be sure to keep you guys updated on what's going on. So here we are looking at the orders page, refreshing. It's not quite 8:30 our time. If they were to release orders, it would be at 8:30 our time. But I'm looking at the calendar here, and I don't see where they're going to be releasing any orders today. So maybe we'll get some orders, maybe not. But let's look at exactly what they could be, doing here. So the background, I'll do a quick digest. I know some of you don't want to get all the background all the time. Others who just come into this, it's good to know. But Illinois enacted a gun and magazine ban January of 2023. It prohibited the sale and possession of 170 plus semi-automatic rifles, shotguns, and handguns, and magazines over certain capacities. Lawsuits were filed in state and federal court. In the state court side, you had the case like from State Representative Dan Calkins go all the way to the Illinois Supreme Court where they ruled against him. You even had cases from, the likes of former Attorney General candidate Tom DeVore, who actually got preliminary injunctions in place for thousands of people. And those cases also went by the wayside in state court. In federal court, you had a collection of cases in the Northern District and the Southern District. The Northern District federal court ruled against the plaintiffs. In the Southern District federal courts, the judge ruled for the plaintiffs, but those were on preliminary grounds, meaning the plaintiffs simply asked, we want an injunction in place while we debate the merits of this case. Southern District granted that. It lasted only 6 days. And then the appeals court reversed that, took the case, and then they heard it and ultimately sided with the state on preliminary grounds, not on the merits. So on preliminary grounds, that's where you've got people in the plaintiffs' groups asking for the U.S. Supreme Court to take those cases. So what we have now is we're still waiting on the orders to come out, and it could be any moment now. We'll sit here and refresh this page over and over again to wait for those orders. But will the U.S. Supreme Court take those cases? Not sure. But if you go and look at the court docket for the Southern District of Illinois, you'll see that, even Judge Stephen McGlynn, who's been hearing that case, he says that the court notes the Supreme Court has not yet rendered a decision. And whether or not they're going to take the case could determine whether the Southern District of Illinois federal court moves forward. They've got a bench trial set for mid-September. A bench trial is set for mid-September on the merits, not on preliminary grounds, not on whether or not there should be a temporary block, but on the merits, final judgment in the Southern District. Whatever happens in the Southern District will then have to go back to the appeals court, but all that would be final action before it goes to the U.S. Supreme Court. But the U.S. Supreme Court could issue orders, possibly as early as today, to indicate whether or not they're going to take the case, or whether or not they're going to continue to sit on that. So here we are waiting, and whether or not they're going to take this case still is yet to be seen. So I'm going to go back over here, refresh. This is live to tape. Order lists. Look at this. All right, so we've got an order list now. Let's go ahead and pull this up. Just do a control search. Barnett. Caleb Barnett, Supreme Court of the United States. Dane Harrell, statement of Thomas J. Let's go, continue on. On petition for writ of certiorari to the United States State Court of Appeals, the Seventh Circuit. Let's read this. The petition of writs certiorari denied. Justice Alito would grant the petition of writs of certiorari. Statement from Justice Thomas. The state of Illinois enacted a law that makes it a felony to possess what Illinois branded assault weapons, a term defined to include AR-15s. The AR-15 is the most popular semi-automatic rifle in America, and there is therefore undeniably in common use today. Heller v. District of Columbia, and also Garland v. Cargill, citing Sotomayor in that. Describing semi-automatic rifles such as AR-15s as commonly available. Petitioners sought a preliminary injunction against the enforcement of the law, arguing that the law violates their Second Amendment rights. The Court of Appeals for the Seventh Circuit rejected the petitioner's request for a preliminary injunction, concluding that the AR-15 is not protected by the Second Amendment. Beavis versus Naperville. According to the Seventh Circuit, the rifle selected by millions of Americans for self-defense and other lawful purposes does not even fall within the scope of the arms referred to by the Second Amendment. This court is rightly wary of taking cases in an interlocutory posture, but I hope we will consider the important issue presented by these petitions after the cases reach final judgment. Thomas goes on to say, we've never squarely addressed what types of weapons are arms protected by the Second Amendment. To be sure, we explained in District of Columbia versus Heller that the Second Amendment's protection extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. And we noted that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, recognizing the historical tradition of prohibiting the carrying of dangerous and unusual weapons. It's not dangerous or unusual, it's dangerous and unusual. But this minimal guidance is far from comprehensive framework for evaluating restrictions of types of weapons, and it leaves open essential questions such as what makes a weapon bearable, dangerous, or unusual. The Seventh Circuit's decision illustrates why this court must provide more guidance on which weapons the Second Amendment covers. By contorting what little guidance our precedents provide, the Seventh Circuit concluded that the Second Amendment does not protect, quote, militaristic weapons. It then tautologically defined militaristic weapons as those that may be reserved for military use. The Seventh Circuit's contrived non-militaristic limitation on the arms protected by the Second Amendment seems unmoored by both text and history. This is pretty compelling, actually, because it spells out a lot of, what the Southern District of Illinois federal courts could do. So we'll obviously hear a lot more about this. No army in the world uses a service rifle that is only semi-automatic. In my view, Illinois' ban is highly suspect because it broadly prohibits common semi-automatic firearms used for lawful purposes. It is difficult to see how the Seventh Circuit could have concluded that the most widely owned semi-automatic rifles are not arms protected by the Second Amendment. These petitions arise from a preliminary injunction. The Seventh Circuit stressed that its merits analysis was merely a preliminary look at the subject. But if the Seventh Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the case reaches a final judgment. The court must not permit the Seventh Circuit to regulate the Second Amendment to a second-class right. So there you go. Justice Thomas writing the order saying that the petition for writ is denied. Justice Alito would have granted the petitions for writ. So what does that mean? It means that the Seventh Circuit case is going to move forward. So again, I'm sure the docket's going to be updated here at the Southern District Court, where you've got that bench trial set for September 16th. September 16th is now the next major move in this case. And will it go to the appeals court? How quickly will the appeals court deal with it? Then when they deal with it, they have their oral arguments, or maybe they just deal with it right when they get it. How long will it take to get to the U.S. Supreme Court? Is it going to be this time next year, where gun owners in Illinois and elsewhere across the country that live in states where they've banned semi-automatic firearms like this, are you going to have to be waiting a full year for this? Rather fascinating where we're at right now. That's not the only case that we've been watching closely. There's movement in some of these other cases as well, but we'll have to save that for another day. So headline here, as we saw it live to tape, the U.S. Supreme Court denying a request for cert in the combined cases of the gun ban in the Southern District of Illinois and elsewhere, and Justice Thomas denying that, going through and meticulously spelling out a whole bunch of reasons why that they think this is an important case, but they don't want to take it on an interlocutory basis in the middle of the case. So, again, the next step in this case is indeed the Southern District of Illinois Federal Court, where they're going to move forward with the case on the merits. It is Bishop on Air. Thank you so much for being with us each and every weekday morning. Again, I want to implore you, go and check out America's Talking Network, because that's where you're going to get all the daily news you need with Illinois in Focus Daily. Like, subscribe, hit that notification bell. America's Talking Network. Just search for it on YouTube. Once you like and get that notification bell, you will be able to join us each and every weekday morning, because here at a date certain, the daily live program, Bishop on Air, will only be on America's Talking Network. We're not stopping Bishop on Air. We'll still do some segments. Like, for instance, when we're analyzing the status of gun ban legislation or other gun laws, or maybe mini documentaries or live chats with the likes of you in the chat room, or with Todd or others. So greatly appreciate you guys being here and being part of this. Like, subscribe, hit that notification bell, share with your friends, all the good stuff. Have yourselves a wonderful rest of the day. Gotta get back to work, especially after this news.
So,